question of how property rights are defined, restricted, and also enforced.
Everyone can hear?
Here we go. I told you it's gonna be Trump Park all over again. Maybe I will stick around a little longer.
So for folks who had not watched the show, which was it was on HBO last summer, it really does an excellent job of weaving together this sort of supernatural fantasy plot line with actual historical events. And the historical event that Letty's sister Ruby refers to in that scene is the eviction and riot that accompanied the Black family moving into the public housing project that I mentioned a few seconds ago. That happened in Trumbull Park in Chicago. And so what sort of is echoing in the background is this history of racist exclusion from neighborhoods, of hyper segregation, and of this particularly, I think, northern tradition, this Jim Crow northern tradition of restricting where Black people can live and how well their families can thrive. The efforts in this scene of Letty to provide a better life for her family, her hopes to use her property purchase to build wealth, again, her American dream will be dashed. Her neighbors post signs based on real life resistance to housing integration on their front lawns, declaring, "This is an all white neighborhood." The police cruise by, as we see, and do nothing. The question left for viewers, and I think the question left for us, is really twofold. So, whose rights and which of those rights ought the law and law enforcement seek to protect? And at the same time, what remedies ought to be available to those whose rights are abridged? This brings us to the phenomenon of living while Black. This term refers to the lived experiences of Black Americans who have been targeted by their white neighbors for police complaints for innocuous behavior. In each of these instances, we see at work a particular strand of racist hostility and aggression, one that we believe has deep roots in American society.
So, what is living while Black? Well, in 2018 alone, in one CNN report, they noted that police had been called on African Americans for the following things: operating a lemonade store, golfing too slowly, waiting for a friend at Starbucks, barbecuing at a park, working out at a gym, campaigning door to door, moving into an apartment, mowing the wrong lawn, shopping for prom clothes, napping in a university common room, asking for directions, not waving while leaving an Airbnb, redeeming a coupon, selling bottled water on a sidewalk, eating lunch on a college campus, riding in a car with a white grandmother, babysitting two white children, wearing a backpack that brushed against a woman, working as a home inspector, working as a firefighter, helping a homeless man, delivering newspapers, swimming in a pool, shopping while pregnant, driving with leaves on a car, trying to cash a paycheck. So driving while Black, walking while Black, swimming while Black, studying while Black, hanging out in a cafe, Starbucks while Black, and having the police called to remove you from the spaces in which you are merely existing. That is living while Black. By modest estimates, the term living while Black has been used on social media to describe these experiences hundreds of thousands, if not millions of times. And since 2018, we've been researching this phenomenon and seeking answers to the following questions: whose rights and which of those rights ought the law and law enforcement seek to protect, and what remedies ought there be available to those whose rights are violated.
So in April 2018, a Starbucks manager in Center City, Philadelphia, telephoned 911 to report that two men had entered the store and were not buying anything. At first glance, the call seemed to be of the run of the mill private trespass variety, whereby a commercial establishment might seek police assistance to remove persons thought to be disruptive or violent. In this case, however, neither condition was present. The two men who were targeted by this manager had entered the store less than 2 minutes before she called police. Video showed that the men sat at a table, as people sometimes do when they enter a busy Starbucks, and began chatting together. And less than 2 minutes later, the police were called. When the police arrived, the two men were arrested for trespass. Video of their arrest, with the men being accosted in the store and led out in handcuffs, circulated on social media, including we have a screen grab here from the video. You can see what is happening in the Starbucks. These images sparked a massive public calls for a boycott of Starbucks due to the perceived racist actions of this store manager. Starbucks ultimately responded to the growing public pressure by closing all of its stores in May 2018 for a day-long training. I don't know if folks remember, Starbucks around the world were closed. This incident at Starbucks was just that, though. It was an incident. It was an anecdote. And it wasn't until that incident sparked massive public outrage that I think Professor Jefferson Jones was inspired to pursue this as a research project. So we were both at a conference in late June in 2018, and Professor Jefferson Jones approached me and asked me what I thought was happening in these cases. I told her I didn't know, I hadn't thought about it much, and she proffered that she thought that these cases were all about nuisance and that there might be something there. And it's not every day that somebody comes to you with such a flash of clarity on a research project. So as soon as she said it, I said, I want in. What are we going to do? Let's do this together. And that's how this started. And as it so happened, over that same summer, this was 2018, and that early fall, there were dozens of these incidents, all with accompanying video witnessing. And in this torrent of incidents, we began to see a pattern. The powerful combination of high quality cell phone video plus social media brought to light a barrage of incidents involving 911 calls reporting that Black people were occupying spaces that the callers believed that they ought not occupy. And in nearly all of these cases, the targeted men, women, and children were in places that they had a legal right to be in and engaging in activities in which they had a legal right to engage. Widely circulated and debated on social media, these incidents all went viral, spawning a series of social media hashtags like Professor Jefferson Jones showed us a second ago, most strikingly, hashtag living while Black.
And so this hashtag, this social media hashtag living while Black, is a play on an older term, driving while Black, which euphemistically describes the violence of racial profiling of Black drivers by law enforcement. Living While Black first appeared as a social media hashtag to mobilize attention to incidents where white people called the police on Black people for engaging in non-criminal everyday activities like those that I read out to you. While the term Living While Black had been previously used to describe the fraught conditions of navigating racist encounters for Black people, the hashtag, again, via this high quality cell phone video and the use of social media, brought the term into the nation's common lexicon. So while Living While Black incidents are not new, they harken back to Jim Crow America and the notion that Black people should be restricted to subordinate places, both in the social hierarchy and in spatial hierarchies. There are some commonalities between now and then, namely that law and its enforcers are being used to draw lines of racist exclusion. And we saw that in that first clip, right? The police officers just drive by, they are in on the scheme. So what's different is that cell phone technology has put this high quality video production and distribution in the hands of the masses. Everyone is able to use this ostensibly objective medium to validate their witness to abuses, whether to the circumstances prompting false 911 calls or to police violence. And the ubiquity of the cell phone does make it easier for racists to call the police quickly, but we think that that's outweighed by the benefit that victims and bystanders are able to reap. So cell phone video corroborates what had previously been dismissed as unreliable. What's different, or what's not different from the Jim Crow era, or earlier eras, it's early in the morning, is the policing of Black people. So that's what's the same. That's our standard. And that's happening within public and private spaces, and the use of law enforcement, again, as this tool of racist exclusion.
So what does it mean for a space to be racialized? Property is racialized when it is ascribed a racial identity or character that includes some and excludes others on the basis of race. Those spaces can be neighborhoods, they can be public parks, they can be avenues or boulevards, they can be sidewalks, among other spaces. Spaces are racialized by the people who use and lay claim to them, irrespective of whether those spaces are legally designated as public or private. The central principle of racial territoriality, and this is a concept developed by my colleague at Rutgers, Professor Elise Body. The central principle of racial territoriality is that what should be shared space is being wrongfully claimed in the name of racist exclusion and in the interest of white supremacy. So when we talk about the racialization of space, we are talking about, and I'm sure if as you are all students at Chicago Kent, many of you live in Chicago, and so me talking about the racialization of space should be sort of putting off some light bulbs for you. When we talk about the racialization of space, we are talking about explicit and implicit references to race and racist stereotypes. So if you're wondering how that looks in maybe late 2020 or maybe early 2021, it looks like Donald Trump's appeals to what he called, quote, suburban housewives, and what we see as a racist dog whistle. So while the social media and public conversation phenomenon that we've been examining emerged only in the past 2.5 years, racial territoriality and the racialization of space is not new. These ideas date from Jim Crow and the hardening of racial lines in our society. Emancipation, as noted by scholars going back over 150 years, did not lead to freedom. Emancipation led to something new, something else that was not free. So although the moniker is new, as is the dissemination of Living While Black incidents via cell phone footage and social media, as I indicated, Living While Black and Blackness as nuisance clashes themselves are not new. In fact, such encounters between and among Black and non-Black neighbors have long been the subject of civil litigation. Commencing in the years following Reconstruction, white litigants began pursuing property law claims sounding in nuisance in an attempt to police and arrest Black proximity. We see in the earliest of these an effort by white litigants to cast Black people and their very nearness as a property harm deserving of legal protection. And what we see, interestingly enough, is that in each of the cases that we examine for this piece, even while courts frequently accepted as valid some social undesirability of Black proximity, that presumptive undesirability did not always result in the granting of a remedy at law. So even as these Jim Crow judges explicitly admitted their own racial bias and struggled to reconcile their personal social preferences with the ostensibly race-neutral common law of nuisance, in decision after decision, we see judges rejecting claims for property relief. So for example, in 1882, James Falloon, an attorney in Hiawatha, Kansas, brought suit against his neighbor, Adam Schilling, claiming that Schilling's construction of tenement houses along the lot line shared with Falloon's property created a nuisance solely because the tenants were Black. In a clear nod to the social construction of whiteness, Falloon included in his pleadings, that's in his complaint, that he and his family, quote, did in no manner associate themselves with colored people. he and his family being white people, unquote. According to the court, the allegation from Falloon's pleadings that Schilling had leased the tenements to persons that he had termed, quote, worthless Negroes, unquote, was unavailing in this nuisance actions for two reasons. First, because as the court rather uncritically noted, the tenants included a minister and his family, who the court noted were not worthless Negroes. These are quotes. Second, the court noted, quote, a Negro family is not per se a nuisance. As long as that neighbor's family is well behaved, it matters not what the color, race, or habits may be, or how offensive personally or socially it may be to plaintiff. Plaintiff has no cause of complaints in the courts. This is from 1882. In Hall v. Moffitt, a 20th century case, petitioners had sought to enjoin the use of land as a Black private cemetery, alleging that a Black cemetery in this location would bring irreparable harm. This is a quote from the pleadings. The injury and damage to petitioners' property and their sense of pride in their community will be irreparable and cannot be compensated in any kind of action in a court of law, unquote. Again, rejecting these claims that the area's Black population already had a public cemetery that it could use, the court noted that the fact that there's a pre-existing cemetery does not permanently preempt the development of successive parcels of land for the same purpose. And in this clumsy attempt at humor, the court noted in dicta, and this is a quote, we can see no reason why even a Negro should not prefer to rest from both hunger and hardship, unquote. On its own, the mere presence of Black people, both in this 19th century case as well as in this 20th century case, did not give rise to a nuisance claim. These claims all failed.
So one thing we need to put this back in the script. The reason that they said that even a Negro should not prefer to rest after death from both hunger and hardship is that the public cemetery was on the other side of a stream called Hunger and Hardship Stream. And so they were saying that even Black people, even a Negro, should be able to rest from hunger and hardship. In other words, saying that our building of cemeteries for the interment of Black remains was not a nuisance. So with all this, we saw an opportunity to explore why this kept happening, this idea that white people were calling 911. We wanted to understand the motivations of these hashtag Living While Black 911 callers, the people that we call our antagonists. It was important for us to consider both current motivations that may be driving this phenomenon, and if possible, historical and structural conditions that may be at work here. And so that's part of why we looked at the older cases. So in the summer and fall of 2018, the archive for our project was being created on a weekly and sometimes daily basis. The archive of video recordings, 911 calls, still images, and social media content and references gave us a mountain of material to work through. In our minds, what we are seeing lent itself to a phenomenological research approach. And this approach and perspective centers the experience of individuals and forces us to suspend our own biases and preconceived notions about what may be prompting certain behaviors. So for us, this means that we would not assume the motivations of our antagonists. Instead, we would use their own words and language to suggest what may be motivating them. Thankfully for us, we had this treasure trove of 911 recordings and transcripts, which allowed us to delve deeply into these incidents. We understand that many of you are working on your own research projects, and we want to encourage you to think broadly about what angle or issue you might explore and what sources you might use. We didn't expect that the treasure trove of 911 calls and video recordings in these incidents would prove so valuable to the arguments that we were trying to make. So, and we also didn't expect that it would lead us to a corpus of historical cases like Falloon and Hall v. Moffitt. and we were able to use those historical cases to analogize modern day Blackness as nuisance.
So, with the exception of the Starbucks incident, perhaps the most notorious Living While Black incident of 2018 occurred in Oakland, California, along the shores of that city's Lake Merritt. We saw in both the April incident at Lake Merritt and subsequent incidents the leveraging specifically by white women of racist tropes around Black predation, violence, and white female vulnerability. In many of these cases, the women who were the 911 callers, you are using the mechanism of 911 emergency services to craft narratives of victimhood and heroism in the face of threats to an imagined public. So in Jennifer Schulte's case, Jennifer Schulte is in this photo, in this slide, the woman on the left. This happened at Lake Merritt in Oakland. In Schulte's case, it's wayward barbecue coals that could potentially threaten the health and safety of children. The woman on the right, it's a 7-year-old child who's selling water on the sidewalk, who the woman claims is making so much noise that it's disturbing the entire neighborhood. This is across the street from the stadium in San Francisco. This imagined public, though, is one that for these women is exclusive and does not, in fact, include Black men, Black women, or Black children. So, when initially confronted about her choice to call the Oakland police to report barbecuers in Lake Merritt Park, Jennifer Schulte displayed steadfastness in the face of her critics, refusing to yield or even to end her call. Seconds later, once she had connected with the 911 dispatcher, Schulte began to cry and claim that she had been harassed. And once the dispatched officers arrived on the scene, Schulte again began to cry, so much so that she was initially unable to communicate with the officers to tell them why she had called. Having aggressively and unilaterally initiated a confrontation with the barbecuers, and after threatening them with the words, quote, "y'all are going to jail," unquote, it was only when she had the attention of the police and emergency personnel that Jennifer Schulte claimed to be a victim of other people's aggression. And in so doing, she strategically tapped into the long history in this country of white fears of Black male predators. Variations of this duo of discursive strategies recur in several of the Living While Black incidents that we discuss in our research. Some of you may recall the incident in New York Central Park last year in May, where a woman said on camera to a man who she was antagonizing, said, "I'm going to call the police and I'm going to tell them that an African American man is threatening me." This is what she says rather flippantly into the camera that the man's sister is actually recording her with. These tropes of Black male predation, white female vulnerability are, as you can guess, antithetical to integration, and together support the establishment and the maintenance of exclusively white spaces under the protection of public law enforcement.
So just the other day, as in Monday, we learned that one of our protagonists, actually antagonists, had shifted her attention to us. Sarah Brash, who you may know as the white Yale graduate student who called police on a Black grad student sleeping in the dorm common room, posted a series of tweets falsely accusing the two of us of trying to get her killed. In those tweets, she referred to us as frauds, liars, and bigots, and even threatened to report Professor Henderson to the president of Rutgers University, a threat that she followed through on. We are now in her crosshairs and learned yesterday that she is putting others who speak out against white supremacy in the same place. So we're in good company. Those others include Kristen Johnson, who is going to be the new assistant AG for civil rights. They include Representative Cedric Richmond from New Orleans, who is going to be in a special and elevated position in the Biden administration. So she's tweeting at all of us and threatening us. But we felt like social media celebrities the other day because she decided to play this game and tweet at our employers and all of that.
I never felt so famous as when she had 0 likes and 0 retweets except for her own. Never been so famous. So last June in Florida, a white resident of a gated community followed, harassed, and threatened a Black teenager who was riding in a golf cart with a group of friends. In a video of the incident that ultimately went viral, the harasser here, Lee Jeffers, can be seen yelling at the sole Black teenager in the group, telling her, quote, "You do not deserve to be in here," unquote, and threatening to have her arrested. This is a child. In fact, in real life, the teen doesn't just deserve to be in the gated community, her family lives on the same block as Jeffers. So it's worth noting here that at the time of the incident, the harasser, and we included 2 images here. So this was images that the child took on her own cell phone. One features him in the street. The other features him in her family's driveway. So this is him standing on her family's property. He's actually the trespasser here. It's worth noting that at the time of this incident, Lee Jeffers, who you can see here yelling at a child, served as a federal immigration official. And while he was initially suspended when this all went viral, he did not lose his job. In fact, he remains an immigration official with the Federal Department of Homeland Security. And just a few weeks ago in New York City, a woman assaulted a Black teenager, falsely accusing him of stealing her cell phone. The video of this assault also has made the rounds on social media. So some of you may have seen the video of this woman trying to tackle this child. Or perhaps you saw her rather unapologetic interview with Gayle King last week. In both of these instances, the protagonists of the harassment believed these children to be out of place. This expectation, this violent demand that Black children justify their presence in response to harassers' inquiries is fully within the Living While Black tradition.
And we see that when we go back and look at the woman who called the police on the child, the Black child who was selling water outside the stadium and outside of an apartment building in which they both lived. But that woman, Samantha Etter, claimed, "This is my property and you don't have the right to be here." So what do we do about this? What are the potential legal remedies? There's some that are being looked at. So in this specific arena of racially motivated 911 calls, some jurisdictions are in the midst of shifting the burden of justice from the victim to the perpetrator. Some cities and states have enacted laws that punish perpetrators of Living While Black abuses. Last year, the city of Grand Rapids, Michigan, passed a human rights ordinance that prohibits crime reporting based, among other things, on the individual's actual or perceived color or race. And such biased crime reporting may result in prosecution for a municipal civil infraction and is punishable by a modest fine in addition to costs, damages, expenses, and sanctions. Also last year, Oregon enacted legislation that allows targets of Living While Black calls to sue those who initiate such calls for civil damages up to $250. So these are all modest. And in the wake of a highly publicized, the incident that was mentioned in Central Park last May, which happened coincidentally on the same day that George Floyd was killed in the streets of Minneapolis, a bill was introduced that had been introduced 2 years ago in the New York State Assembly, gained new life. It was already illegal in New York to make a false 911 call. The Central Park incident with Christian and Amy Cooper prompted renewed interest in that bill and in making it a hate crime to call 911 and make false accusations of criminal activity based on race, gender, or religion. So this is now the law in New York. In addition, to statutory remedies, there have been calls to better train 911 dispatchers. And I'm sorry, I skipped over one. There is the Karen Act in San Francisco, which would make it illegal for people to contact law enforcement solely to discriminate on the basis of a person's race, ethnicity, religious affiliation, gender, sexual orientation, or gender identity. And under that ordinance, that will allow individuals who are harmed by these calls to sue for damages up to $1,000. So in addition to these statutory remedies, there have been calls to better train 911 dispatchers so that they ask questions aimed at rooting out bias rather than unquestionably sending officers to the scene. We saw that happen in the Oakland Merritt Park case. The 911 dispatcher actually frustrated the caller by saying, well, tell me more. She asked about race, and our caller at first refused to tell her race, and then the 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 um, the 911 dispatcher made more and more inquiries to the point that she was able to put the police on alert. The dispatcher was that this woman might have some mental health issues, and that he should go in there cautiously, not taking her word for what was going on. And later, when we look at the video of how the police officer responded, it's clear that he knew that she might not be a truthful caller. So he did not just take her word for it. So finally, the police have to be better trained to respond to instances that may be living while Black occurrences, and better protect the victims of this false reporting. So we leave you with this question, and it takes us right back to it. We're wondering, what is justice? What is the role of the law and of lawyers? How might the law further the goals of a multiracial democracy? What remedies ought to be available to those who are targeted and harmed by acts of racist exclusion? And given what we saw last week in the Capitol riots, what hopes do we have of actually living up to the promise of such a democracy